Hello, everyone. Today and this week, we will be talking about the K-1 or Fiancee Visa. I'm Raluca and I provide family law, immigration, and estate planning services to my clients. Nina Clear, my marketing and office manager, is here with me. Thank you for your likes, shares, watching this video. Every time you like a comment, it helps other people to see my video, and I really appreciate that. I would love if you can type #live if you're watching live, or #replay if you're watching at another time.
Okay, so first, let's tell everyone what form they use to file for a fiancé visa.
Sure, it's 129F.
And do you recommend that an attorney helps with filing this?
I do. Previously, a fiancé visa was one of the easiest to obtain, but we have seen clients who have been denied more frequently.
Why is that?
With everything in immigration, this administration is trying to reduce the number of immigrants as much as possible, so they're being more strict than they were in the past. They are also requiring face-to-face interviews with the U.S. citizen and being more strict about background requirements.
So does that mean fewer are being approved?
Actually, the stats are a little bit confusing. While the approvals were down in 2017, the most recent year that we have complete information for, to 40,208. In 2016 had been the highest in a long time at 44,252. But 2017, even though it was less than 2016, was still higher than 2013 and 15. We'll see what will happen in 2018, what happened in 2018 when the stats are released. However, it seems like the overall approvals of both the applications and consular process interviews are down to a low 66 to 80% rate, whereas before 2016, they were over 95% approval for all applicants.
And I read that 2016 had a 37% refusal rate after the consular interview. Is that right?
Yes.
Is there something that you can do after you're denied?
Yes, you can appeal that decision, but only 55% of those who appealed were approved.
So it sounds like the best thing to do is be approved at the first time you submit it.
Yes, that is true for almost anything in the immigration field.
And there are two stages in which the denial can happen, right?
That's right. You can either be denied as the U.S. citizen applicant when you file the I-129 with the immigration agency, or you can be denied as the foreign fiancé during the interview at the consulate.
And tell us about the actual denials.
Sure. There are basically three categories of denials. One is the consular denial, also known as the 221G. Usually the consulate is not convinced that you're going to come here to get married. Second, you don't meet the minimum eligibility requirements. And third, if you are inadmissible due to past actions.
Looking at this long term, if you want to be approved for a fiancé visa, what should you not do?
There are a lot of things that you should not do, but a few include: don't be married, don't try to proceed without a legal divorce. The fact that your priest was telling you that you're not divorced anymore is not a legal divorce. Another one, don't commit a crime. Don't lie, especially in your applications. There are a whole list of items that could keep you from being approved, and I would be happy to have a consultation with someone who is contemplating about applying but has concerns. One of the biggest things I have seen people do is to come in U.S. on a tourist visa and then getting married.
And why is that a problem?
Because you can be deported, saying you came here under false pretenses.
And then what happens?
Well, it could cause you not to be able to get your green card or U.S. citizenship.
So we talked about a financial affidavit in other circumstances on some of our other videos. Do you need to file one for a fiancé visa?
Yes, you do.
Sorry.
Okay.
And is it the same requirement as the other financial affidavit?
Actually, okay, yes, you must still make more than 125% above the poverty level, including all people in your household. But this one is a contract that is legally binding only for 3 months.
Okay, so is there anything that you might want to avoid besides those we already talked about?
Yes, a few things that USCIS and the Department of State see as concerning besides what we talked about is, for example, when did you meet and how long did you get to know each other? They look on did you get engaged the first time you met? Did you file the I-129F right after you met? Did you start a relationship before either of you were divorced from another person? These all could probably be a video on their own. If you have individual concerns and questions, please submit them and I will try to answer them in another video.
Okay, so tell me about the 2-year rule. Do you have to have known each other for 2 years?
No, you don't. You have to have been in each other's presence within the past 2 years. So that means you had to meet at least once in the last 2 years. But you could have known each other for only 5 days. But remember that if you've just met and filed your I-129F, that may be cause for concern from the Department of State.
So it sounds like there's a lot involved with this type of visa. Is there anything you must know to apply?
Yes and no. It is less complicated than some, but no immigration things are completely straightforward. Yes, you must be a U.S. citizen to apply, meaning you cannot be a green card holder. And you must also intend to actually marry within 90 days of your fiancé coming in the U.S. There are some other things we can cover in other videos, but this is long enough today. So thank you so much for watching. We will be also talking about costs and timelines next week, as well as some information about family law this week. Thank you. See you tomorrow.